I am Maya Shulman, your family law and formation practitioner. This is my podcast, Family Law Uncensored. The topic for today is divorce mediation versus divorce litigation. I'll give you the pros and the cons, what to do, what not to do, and why you should favor one versus the other. The main benefits of choosing mediation over litigation are you are in control. You get to choose who you mediate your case with. You get to choose who you mediate your case by. You get to choose the dates on which you set your mediation. You get to choose the retired judge who will preside over your mediation. You get to choose the location for your mediation. And you get to choose how fast or how slow your case will proceed in mediation. I highly recommend you look into this before you run to court and spend countless hours and countless thousands of dollars on sitting in the courtroom with your spouse. Divorce mediation is particularly effective when you deal with the custody and visitation of the minor children. Again, let's remember mediation is completely confidential. There's not a court in the state of California or any other state that will break mediation privilege. Whatever you say in mediation, other than if you make a threat to someone's life, will be completely confidential, and that promotes frank discussions about your case, not to be taken for granted and not to be taken lightly. Mediation helps to reduce emotional stress of divorce for several reasons. The first is because you are allowed to speak freely. There's no judgment, or I should say there should be no judgment in mediation. The mediation cases I handle with the retired judicial officers that I handle provides frank, confidential, and more relaxed atmosphere for conversation. And conversation is what's lacking when you go to court. You have no time to converse. The judge will not allow you converse. The judge is there to make orders. Mediation, on the other hand, allows for you to express your thoughts, express your desires, express your positions, and invites you to a dialogue. And that's what one should have, because main reasons we encounter problems in litigation is because there's a lack of conversation. There are a couple of scenarios when litigation is the only way to solve a controversy, and that is because unfortunately, not every case is mediation situated. Not every case is going to be resolved in mediation. Sometimes there are issues that need a judicial assistance. Sometimes the parties are so far apart that no matter how skilled the mediator is, he or she will not be able to bring those two parties to a middle. And sometimes the issues, such domestic violence, simply cannot be mediated because in domestic violence, you have crossed the border. You have breached my trust. When those two things happen, mediation will not succeed. And when those two things happen, that's when you know you need to litigate at least those two issues. Well, first of all, it's a bit of a misnomer. A mediator in a law case, in your divorce case, has to be an attorney. So being a mediator does not accept you from having a law license. You could be a mediator and an attorney at the same time. So you would be called attorney mediator. You will have a law license, you will have knowledge of family law, and you will use that license and your experience in your office and in courts to tell your clients why mediation will succeed and tell them what the case outlook is going to look like and tell them why mediation in their particular case is the better way to get out of the family law dispute.
Okay, how does mediation work for couples with complex or financial or custody issues?
For couples with financial issues that are more complex than others, in mediation, we can bring in an expert. We can bring in a forensic accountant, a person who knows how to count, how to calculate, how to do formulas, how to help us divide assets and divide debts and apportion family community property estate. And sometimes that person, such as forensic accountant, is indispensable, especially in cases that have high net worth assets. And that is who we employ in mediation. And therefore that person will also be covered by mediation privilege, and everything that person does in mediation case will also be completely covered from disclosure, other than a final product which then will be filed with the court. Mediation is only binding when it produces a final contract agreement that is signed by both parties, and that final signed documents will be legally binding. In fact, there's a code section that provides that all agreements signed in mediation will then be turned into a final binding judgment. So yes, contracts signed in mediation process are going to be legally binding. The costs potentially involved in mediation are going to be substantially less than the cost involved in litigation, and here's why. When you work with the mediator, you work with one attorney mediator. You don't have to have separate counsel. You can, but you don't have to, because attorney mediator will tell you what you need to do, and more often than not, the attorney mediator will provide and prepare documents required from each side. You can, if you want, of course, then have your own separate counsel look it over, give you separate advice, provide you with more information if you desire, but not necessarily in mediation that I handle in my office. I don't necessarily ask counsel to be involved unless the parties insist on it. So really, it's up to you what you want. The beauty of mediation process is you can make it what you want. You can make it work for you the way you want it. You can make it work for you on your timeline. You can make it work for you on your finances, on your deadlines, and really you can make it work for you at your speed. Usually mediations in my office take no more than 6 months, and I will tell you, having done litigation work, that 6 months is nothing compared to a case that goes to a public courtroom. Once you're in public courtroom, you're looking at a minimum of 1 year for a case that does not have too many high net worth assets. And if you're looking for high net worth assets case, that case will take a much longer time because you will have to bring in experts, just like in mediation that I've discussed a minute ago, and that expert has to prepare work and file it with the court and testify, and all that takes time. I was in court today and the judge was assigning dates for my case. Today is January 22nd, 2025. The dates that I have gotten from my case just to get to the next step are in June. So we're looking at a 5 months lag time to get to the next step. The main risk reward for mediation versus litigation is something that you really can't quantify, but you can only understand it once you get into the process and begin the case. And what I'm talking about is the following. In mediation, you have a mediator who works on your timeline and works with you on your schedule and does things at your convenience, at your leisure, give or take, and when you have available time. Once you are in court, you don't have that. You don't have an ability to manage your schedule. You don't have an ability to manage your time. And more importantly, you have delegated your entire life to a person who doesn't know you, who doesn't have time to sit across the table with you, who doesn't have time to have a conversation with you. You have delegated your entire life to a stranger who will simply make orders based on what you wrote on your papers, based on what your spouse wrote in your papers, and that person will make orders based on how she or he sees the case and how she or he will perceive in the term that is called in the interest of judges. That is not necessarily where you want to be. That person is not your friend. That person is a judicial officer who swore to uphold the law. That person is not necessarily going to be fair. That person is not necessarily going to be fast. That person is not necessarily going to keep your confidence. And that is a huge disadvantage of litigation versus mediation. There are a number of misconceptions that are existent when you talk about divorce mediation, and I would be the first to tell you that the first misconception is that mediation is going to be expensive. That is absolutely not true. Mediation is designed to save your assets. Mediation is designed to minimize attorney's fees you spend on your case. Mediation is designed to also help you keep your sanity, because mediation is designed to allow you express yourself in a confidential fashion. Litigation does not provide for any of those. Mediation can be used at any stage of the case. Mediation can be used even before you file your case. Mediation can be used after you file your case and when you have received your first hearing date. Mediation can be used after you have had your first hearing. Mediation can be used really at any time. It also can be used after your case has concluded and possibly some post-judgment issue have arisen. So really, mediation is a Band-Aid. Use it anytime you want. Use a small Band-Aid, a medium Band-Aid, or a big one, but really just use it to your benefit. The way I prepare my clients for the mediation process to ensure that they are successful is a conversation that I have with them, and I tell them they have to be candid. They have to allow for mediation to work, and for it to work, they have to be honest, they have to be candid, they have to be forthcoming, they have to voluntarily provide information, and they have to compromise. Mediation will not work if the parties do not compromise. Mediation will work if both parties are intent on coming to a middle, if both parties are intent to come and have a frank conversation on resolving issues, not making more issues. That's how you succeed in mediation. The factors I consider when I advise clients if they should mediate or litigate their divorce are really simple. Clients who will mediate will absolutely benefit in safeguarding their assets, in safeguarding their emotions, in safeguarding their children from being exposed to the court process, in safeguarding their pets, frankly, and safeguarding their everything else that they have accumulated during their marriage, whether it's being kids, whether it's being four-legged kids, whether it's being their assets, their debts, their homes, their boats, their cars, their anything and everything. So anybody who wants to be a business person in this fashion, in this universe of family law, they should and they should want to choose mediation. That concludes my presentation for my podcast. More good stuff to come. Please check me out. My website is www.shulmanfamilylawgroup.us or www.yourfertilitylawyer.com. I'm available and foundable and reachable on social media, email, text, Zoom, Viber, WhatsApp, any and all forms of communications. My phone, text, and fax are one number for all, 818-222-0010. Thank you very much and be well.